If you have a controversial estate plan, a revocable living trust plan may make it more difficult for an heir who feels he or she has been wronged by your plan to be disruptive. One type of controversial estate plan is when you're disinheriting somebody who would benefit if there were no will. For example, suppose you want to disinherit a child. Keep in mind that the probate process is an opportunity for people to come in and complain. So let's review that part of the probate process for a moment. If you don't have a revocable living trust and you don't avoid probate, that means your executor will be taking your will to the probate court and making an application to the court, which asks the court to find that this document, the purported will, is actually the last will and testament. Before the court does that, it will require that notices are sent to all the people who would inherit your property if there were no will. So that means when the will gets presented to the probate court, if you're married and have children, all your children and your spouse will receive a notice, because the statutes that apply when there is no will say that your heirs are the beneficiaries. If you're not married and you have no children, then the statutes would identify the people who are your heirs and they would get notice. That would usually be your closest family relationships by blood. In any event, all of these people get notice, and if you've disinherited any of them, they might be upset about it. When they get the notice would typically say that the will has been submitted to the probate court and the court has been asked to admit the will to probate. The notice informs the heir that, unless the court hears from the disgruntled heir within a certain period of time, the court will approve the application and admit the will to probate. So in effect, that notice is an invitation for the heirs to come in and complain. That's part of the probate process. If you avoid probate, there's no notice requirement of that sort. There's no process whereby, before the trust is effective, it needs the blessing of the court. So with a revocable living trust, everything's already in place, and if a person wants to complain about it, that person is put in a position where he has to attack something, the revocable trust, that already exists. Compare what happens in probate. In that case, when the executor makes the application to the probate court to admit the will to probate, the contesting heir is put in a position where he's contesting something that hasn't happened yet. He's preventing something from the beginning instead of attacking something that's already in place. The contesting heir is in a stronger position in that case, because even if there is very little merit to the contesting party's claim, estate settlement cannot proceed until the court imposes some solution. If the revocable living trust plan avoids probate, the trustee of the trust has already been granted the authority to perform as trustee by the terms of the agreement. The contesting party can't stop that from happening. It has already occurred. The contesting party can't stop the trustee from proceeding with estate settlement without some evidence that there is a compelling reason to do so. So if your planning is done through a revocable living trust, it's much less likely that unhappy heirs would attempt frivolous claims. It's much easier to pursue a frivolous claim and be disruptive in the probate court. We already talked about how a revocable living trust could be a good way to manage your assets for you if you become incapable. Keep in mind that it is also a good way for you to provide for others who you're taking care of. Suppose that while you're alive and well, you're supporting others and you're concerned that your incapacity will disrupt that support. The revocable living trust can be a good way to make certain that in the event of your incapacity, the support that you're giving to others will not be disrupted. Here's another important feature of a revocable living trust. All the planning work when you adopt a revocable living trust plan, especially the process of retitling your assets so that all your assets are owned by the revocable living trust, can make life simpler for your surviving beneficiaries after you pass away, because if you do the work completely, at your death, all the work of collecting the assets will already be done. The assets that you retitle in the name of the trust will already be in the hands of the trustee. The trustee won't have to go through the process of figuring out where everything is. The trustee already will know where everything is because it's already in the trustee's name. On the other hand, when you do not have a revocable trust plan and you don't avoid probate, your executor, who will be appointed under the terms of the will after your death, won't have possession of any of your probate assets without doing a lot of work at that time. Part of the executor's job is to identify and find all the assets and take possession. How simple or complicated that may be will depend on how organized you are and what kind of records you leave behind at the time of your death. But no matter how careful you are about your records, the executor has no way of knowing if something is being left out. The executor's first questions are, how to identify the assets, what are the assets, how do I go and collect them? It will be a puzzle, and the executor feels compelled to pay attention to a lot of details that may be irrelevant. One can never know when there's going to be a clue that an asset exists, so the executor needs to look at every piece of paper that the decedent leaves behind while looking for clues about assets. The executor's job at the beginning stages can be daunting. On the other hand, if you have a revocable living trust plan and you retitle and organize all your assets before you pass away, that can create a much simpler situation for the trustee of the revocable living trust and the surviving beneficiaries. Another way that a revocable living trust plan can make things simpler for the surviving beneficiaries involves avoiding another feature of the probate process, which can create problems for the surviving beneficiaries of some clients. For example, think about a client who's estranged from his family for whatever reason, and he hasn't seen any of them for decades. The client has no idea where his family members are. He has moved on, and so have they. Now he has a new family, not related by blood, but by affection and mutual respect. Keep in mind, when this client passes away, part of the probate process is sending a notice to the client's closest family members, and who those close family members are is determined by the biological relationship. In situations where the client is estranged from such family members, they can be difficult to find, and finding them could result in an unpleasant and awkward situation. To avoid that type of situation, the client might want to avoid probate and plan to have his estate settlement done through a revocable living trust. Consider one more reason why clients might want to use a revocable living trust in their estate plans, and that relates to the accounting requirements for trusts that are established under the terms of a will if probate is not avoided. You may recall that I said that trustees of testamentary trusts, that is, trusts that are established under the terms of a will and remain subject to probate court jurisdiction, the trustees of such trusts are required to file accountings in the probate court. That increases not only attorney fees and accounting fees, but also probate court fees. Not long ago, the total probate court fee for such accounts was capped at $750, but the fee structure was changed. This slide shows in general, but not precisely, how the new fee structure works. In general, the probate court fee for accountings is now 0.5% of the value of the trust times the number of years that the account covers, subject to an annual cap of $500. That can increase the total cost of accountings in the probate court quite a bit. Keep in mind that the old fee structure hadn't been changed in many years, and it's easy to make the case that the fee increase was justified. In any event, that fee can be avoided if, instead of establishing testamentary trusts for beneficiaries, the client uses trusts established under the terms of a revocable living trust. Consider, however, that even if probate court accounting fees are avoided by avoiding probate via a revocable living trust, if the trustee accounts to the beneficiaries and asks for releases, the trustee or the trustee's attorneys will be doing much of what the probate court would do as part of the accounting proceeding in the probate court. In other words, there would be additional attorney and accounting fees associated with settling things with the beneficiaries outside the probate court. Depending on the situation, there's no guarantee that avoiding the probate court fees for accounting will result in savings equal to the full probate court fee. Now let's talk about bogus reasons for adopting revocable trust plans. We'll call them non-reasons. It's very common for us to see clients who have already heard something about revocable living trusts, and they come in with the impression that if they don't do a revocable living trust, when they pass away, their estates are going to have to pay up to 50% of their estates in estate taxes, and that the only way to save taxes is through a revocable living trust. They hear other things about revocable trusts too. So I wanted to list a few of the bogus or non-reasons for considering revocable living trusts, because some of these impressions that clients come in with are just plain wrong. The claim that a revocable living trust is necessary to save estate taxes and income taxes is false. What's true is that revocable living trusts are really tax neutral. It is probably true that with proper drafting and attention to tax techniques, everything that you can do to save estate taxes by using a revocable living trust, you can do with a will, and everything you can do in a will to save estate taxes, you can do by using a revocable living trust. Often exorbitant probate court fees are brought up as a reason to avoid probate. This is a chart that shows how the probate court fees in Connecticut are calculated, and this is true whether or not probate is avoided, because, as I've said before, the probate court fees are based on the size of the estate for estate tax purposes. You can see that for a $500,000 estate, the probate court fee is a little bit more than $1,800 plus 1/4% for each dollar above $500,000 until you get to $2 million when the rate is increased to 1/2%. When the size of the estate gets to $8,877,000, the probate court fee is capped at $40,000. The $40,000 cap was made effective July 1, 2016, after an uproar resulted when previous legislation removed the cap. The capless system lasted for 1 year until July 1, 2016, when a cap was reinstalled at $40,000. That's all we have to say about revocable trusts and probate avoidance for now. In our next segment, we'll talk about gift planning.